Each side will have 15 minutes to present the arguments. The appellant may be able to reserve up to 5 minutes. And this is not relevant to this case, but yet we always try to say it in case we forget sometimes, and that is don't mention names of victims or minors. Please stand behind the lectern because it will be recorded and it will be posted on YouTube. So just introduce yourselves, please, and let me know as the appellant how much time you want to reserve, if any.
Good morning, Your Honor. Amy Bachman. I'm counsel for the appellant. I think I'd like to reserve 3 minutes.
That's fine, thank you.
And Teresa Dirasamar, Your Honor, is representing the appellee.
Thank you. You may proceed.
Thank you. Good morning again, Your Honors. May it please the court. My name is Amy Bachman, as I mentioned, and I represent the appellant, Laurie Phillips, in her capacity as special administrator of the estate of Sylvia Johnson. This appeal is before the court this morning because Ms. Johnson was improperly denied long-term care Medicaid benefits due to agency delay. There are 3 primary questions before the court this morning, and a finding of error on any of these is cause for this court to overturn the lower court's opinion. The first question is whether the lower court erred when it failed to find that Ms. Johnson's Medicaid benefits were improperly denied as a direct result of ODJFS's failure to timely process Ms. Johnson's Medicaid application pursuant to federal and state law in place at the time. The second is whether the lower court erred when it did not properly address Ms. Johnson's arguments that she was prejudiced by the inaction of ODJFS on her application for Medicaid benefits for several months. And the third is whether the lower court erred when it failed to overturn the magistrate's finding that the administrative appeal was not in violation of state and federal regulations or in violation of Ms. Johnson's rights to due process. The lower court upheld the magistrate's decision and determined that the ODJFS administrative decision, which upheld the Medicaid denial, was proper and agreed with ODJFS. The magistrate, however, in her decision was in agreement with the estate that there were many errors and delays in the processing of Ms. Johnson's application for Medicaid benefits. Ms. Phillips is seeking to have this court overturn the lower court's decision and in doing so, remand this matter back to the agency for further review based upon the evidence in the record. The Medicaid program was authorized by the Social Security Act in 1965.
Counsel, if I interrupt, just to make sure I understand exactly what did happen, because there seems to be a little bit of disagreement as to the first application.
Mm-hmm.
So you seem to say in your brief, and I'm not even sure, I think that the magistrate might even have agreed, that there was the first application that was not decided or ruled on. It was put aside when, unfortunately, when Ms. Phillips passed away.
Correct. So there were, well, yes. The short answer is yes. There were 2 applications here in this particular situation. The first application was submitted October 7, 2016 by Legacy Place, which was the facility where Ms. Johnson was living until she passed.
She was alive at that point.
Correct. She was alive until November 10th, 2016. So they submitted the application in October 2016, October 7th, while she was still living. And that application sought benefits beginning on October 1st and 3 months of retro coverage, which would have gone back to July, August, and September 2016. Now, the law in place at that time, OAC 5161-2-01 subsection K, required that the agency make an eligibility determination of Medicaid applications within 30 days. So that would have been approximately November 8th. She still would have been alive at that point. This included the gathering of any verifications that might have been required. In this situation, she passed November 10th, and then on November 11th, the facility went back and looked and said, hey, wait a minute, we didn't get anything. We don't have a case number. We haven't gotten a verification checklist. We've heard nothing in response to the October application.
I want to stop you.
Right.
Because that was confusing for me. So when you submitted the October 7th, 2016 application, I thought at first you had indicated that there was certain items requested for verification, and then they changed those items later on.
No.
Okay.
So when the November application was submitted, November 11th, which was the day after Ms. Johnson passed, that's when we finally got a case number and they began to process the application. But they threw out or ignored the October 7th application date, and the date of record for the application became November 11th, 2006. So that October application just went into the wind. It never got processed.
Well, why does the estate indicate that they requested additional information for verification? And
Because they
didn't
did.
request any verification.
They did, you're correct that they did, but it was much later. So in the timeline, what happened was, the November application was submitted when nothing was heard in the 30 days, and she died from the October application. The November application was submitted, and then a couple days later, November 16th, I believe, a verification checklist was sent out for the November application. And Legacy Place did submit verifications, but then after they submitted verifications, absolutely nothing happened. They didn't hear anything, they didn't get another verification request, there was no notice of decision issued, there was no further communication. So at that point, Legacy Place began to check MITS, which is the benefits system. I apologize, I don't know exactly what it stands for, but they began to check MITS. And finally, in early July 2017, which at this point is 10 months after the initial application and 9 months after Ms. Johnson had died and the second application was submitted, suddenly she had coverage for November 2016 appear in MITS, but there was still no notice. So this is where your question comes in, and this is where it gets real interesting. Legacy Place contacted Job and Family Services to say, hey, why did you only approve November? What happened to the retro months that we requested? And at that point, JFS again began to process the application. I guess at that point, it was either at that point or a little bit later, they admitted they had stopped processing the application in November because Ms. Johnson had died. And so in July of 2017, 10 months later, they issued a second verification checklist after they had already approved the November 2016 benefits. And then they came back and said, well, the November 2016 approval was in error, but they still allowed it to stand. They allowed the coverage to stand. They didn't take the coverage away. So after she had been approved for a month, and after 8 or 9 months had gone by, suddenly they start to process the application again.
When you say they start to process the application, you mean the November
The
application?
November application,
And
correct.
did the November application ask for the same period of retro coverage up until July, or could it only ask for?
It could not, because you can only ask for 3 months prior to the month of submission, so it would go back to November 1st, and then it would be August, September, October. So she also lost the July dates, it was about 8 days. But in any event, so when they started to process the November application again in July, despite having deemed her eligible for November 2016 coverage, suddenly a checklist comes out asking to verify 91 individual transactions that were conducted between September 2014 and August 2016. And keep in mind, most of these dates were dates that Ms. Johnson, who was mentally competent, was living in the community on her own, doing her own banking, taking care of her own affairs. Now she's dead, and there's nobody who's going to be able to verify any of these things that they want to know about at this point. And the other piece is that these verifications that were requested in July of 2017 were not requested when the November 2016 checklist came out. So this is new stuff that came up months and months after the fact. So there are numerous errors, and I laid them all out for you in my brief, but just to touch on some of them, obviously the October 7th, 2016 application was not processed at all, which, had it been processed, she would have been living. Had it been processed in 30 days, she still would have been living. The second error, of course, they had to submit a second application, which they submitted after she passed away. At that point, many or all, in this case of her verifications from her personal banking information became unavailable because the person who knew about them was dead. And even if the family had wanted to cooperate, by July of 2017, they were gone. November 2018, they issued the first checklist. It was more than 30 days after the initial application in October. Granted, they paired it with the November application, but again, we're just completely forgetting there was an initial application that went in. Then they failed to issue a decision upon receiving the verifications. They failed to issue a decision within 30 days even of the November application. And it was only later that it came to light that JFS had stopped processing that application altogether because Ms. Johnson had died, which was not appropriate because the requested coverage was obviously for months when she was living.
And retroactive.
Correct. Then in July 2017, 9 months later, no notice was issued, but suddenly coverage appears in MITS. And Legacy Place is told, well, she shouldn't have had the coverage for November 2016, but then they don't rescind it.
So that Legacy Place was actually paid for November of 2016.
For the 10 days, yes, for the 10 days that she was living. And then again, they began to explore eligibility in July 2017, after her application had allegedly been pending for 9 months, and they issued another verification checklist 10 months after, where they asked for all these verifications that, you know, went back to 2014 and would have been personal knowledge of the deceased, but may not have been knowledge of anyone else. And then, of course, there's some notice issues that we mentioned in the briefs. September 5th, 2017, JFS actually did send a notice dated June 5th, 2017, 3 months earlier, which stated that Ms. Johnson's Medicaid would end on June 30th, 2017. And that notice was actually appealed, or received on the actual appeal date, which was September 5th. But JFS had conceded in the record here that there was no proper notice of denial that was ever sent in this case at all. And JFS has repeatedly conceded to these errors throughout the record. I cited to those in my brief as well. And then the magistrate in her decision also recognized that the agency did have fault in making these errors. You know, the record demonstrates, and I think I pulled this out, quote, that JFS wholly failed to timely process the application that was submitted on October 7th of 2016. And then, of course, we know that the November application was submitted, and that one didn't get decided for months and months after, and it appeared 8 months later, coverage appeared in MITS, and then it started processing again.
Well, I guess the argument, though, is we did make some errors, but at the same rate, you don't get automatic payment just because we didn't process it the correct way in a timely manner.
And I understand that, and I'm not suggesting that automatic payment is what we're asking for here, but what we're asking for is for them to reopen the application and consider the application with the best evidence verifications, because, again, at the time that they requested the 2014 bank account information in July of 2017, this lady had already been deceased for 9 or 10 months. She was the one with the personal knowledge of how she spent her money. So if they were asking, you know, what were these specific things for, she would have been the person, and she was alive in October of 2017 when the first application was submitted, and could have potentially offered information about what those things were. But by the time they asked for them, way down the road in July, after granting the November 2016 coverage without that information, and even if it was an error, allowing it to stand, we're still in a position where the information about those verifications is unavailable at this point, and because it's unavailable information, we're asking for it not to be considered.
And counsel, I apologize because I was asking you questions and you are in your rebuttal time. Do you
Okay.
wanna just,
Yep,
you wanna wrap it up? Yeah.
I'll just end there, thank you.
Thank you. Good morning.
Good morning.
You may proceed.
Teresa Dearasummer, again representing the Ohio Department of Job and Family Services. May it please the court. We're asking this court to affirm the decision of the lower court, which correctly upheld the finding that Ms. Johnson was not eligible for the 3 months of retroactive long-term care Medicaid coverage she sought because her resources were not able to be verified. And Ohio law does require that an applicant's eligibility for Medicaid be affirmatively determined, that they be found eligible, that any required verifications of that eligibility be submitted before an application can be approved, regardless of any agency error or delay in processing that application.
Counsel, how do you reconcile that position with the fact that she was approved for and Legacy Place was paid for November 2016?
Ms. Bachman pointed out some procedural shortcomings throughout this case, she is correct that we have not disputed those facts throughout the course of this appeal. That approval letter was issued in error. There was testimony to that effect at the state hearing. The application should have been denied. And that was the ultimate finding from the state hearing process. At the end of the state hearing and then the administrative appeal, that Ms. Johnson was not actually eligible for the Medicaid benefits she sought, but she apparently was still able to retain those 10 days of eligibility for
And that's my point, because it seems like that is inconsistent with your position, because the argument from the Department of Job and Family Services is that you cannot pay somebody unless all the verification is done. Yet, you did pay somebody, and you didn't withdraw that, so it seems like there is some discretion with that.
So, I do not believe that that is in the record. I'm not, I'm not questioning Ms. Bachman's statement to that effect here, but I do not believe that the record reflects that Legacy Place was paid for those 10 days of November and that remained in effect. I think it also, I think the difference is there were 2 notice letters that were issued ultimately to Ms. Johnson. One was both on June 5th, 2017. One granted her Medicaid benefits for November 2016, and then one denied her Medicaid benefit. So I
don't mean to confuse you.
No, it's all right, it's a valid question. The issue at the state hearing, for whatever reason, was limited to from the period of retroactive coverage, the 3 months prior to November 1st of 2016. I'm not sure that the record reflects why the November coverage wasn't.
Well, we can look at that, right, we can look at the record for that. Thank you.
I will say, to answer your earlier question regarding the October 2016 application, there was testimony at the state hearing that the county never received that application. They don't have any record in their system of receiving the October 2016 application. The only application they have a record of receiving was the one dated November 11th, 2016. And then I believe within 5 days of that, on November 16th, they submitted their first request for verifications. It took, I think it was the end of December when that request was responded to, and the representatives for Ms. Johnson submitted over 250 pages of her financial records to the county for them to begin processing. It did take a while for that process to be completed. It wasn't until the following summer that the county followed up with additional requests for verification. But as part of the application process, applicants for long-term care Medicaid are subject to what's known as a 5-year look-back period, where their resources from the past, their transactions for the past 5 years are looked over to confirm whether or not any of them were considered improper, meaning to see whether they're giving their money away for the purposes of qualifying for Medicaid, essentially. So as part of that look-back process, an applicant is required to verify any transactions that the county has flagged as needing additional information. And the Ohio Administrative Code 5160-10201, subsection I, is clear that until all the eligibility factors are met, regardless of any agency error or delay in processing the application, Medicaid benefits cannot be awarded. That is what the lower court found as well. The lower court acknowledged the procedural issues that are in this case, but ultimately found that the plain language of the law required the denial of her application for those benefits.
Okay, I want to make sure I understand, because, reading the briefs, and you just said that, the trial court everybody acknowledged there was errors. I'm not sure I understand what the errors were now today, because you're saying that the October one wasn't ever received, so they're not responsible for that. You're not responsible for that. Ohio Department of Job and Family Services, right?
Right, yes.
Okay. And then the November 11th one was received, and you sent out notice of verification for certain items, which they responded to, and then in going over the verifications, you saw other items that were necessary. So why are you admitting there were errors? What are the errors then?
We're admitting that that the application, the eligibility determination was not made within 30 days, as required by the rule at the time.
But the
And we're
statute
al-
says you have to notify them that you can't, there's reasons why you can't verify or you can't approve the application within 30 days, right?
Yes, well, the application could have been denied for failure to verify resources. So we're acknowledging that there was a delay beyond the 30 days in processing the application. We also acknowledge that there wasn't a notice of action specifically issued to Ms. Johnson denying her application dated November 10th and denying the retroactive coverage. Though that issue was addressed fully at the state hearing, the notice itself didn't speak to that specifically. But it's primarily the delay that it wasn't processed within the 30 days of receiving the application. That it wasn't, I shouldn't say it wasn't processed at all, that the application wasn't approved or denied within those 30 days. But that is because it wasn't approved because the law requires all verifications to be met. Other courts of appeal in the state have found that. We cited 2 cases from the 7th and 8th districts that found that unless an applicant has been found eligible for Medicaid, even if there's been an agency delay, those benefits cannot be awarded.
In looking at those cases are a little different though, because there was already, these people weren't eligible, period. Here, there was a delay in regard to denial or approval, like you said, and there was no finding that she definitely was not eligible. It was just a matter of lack of information at this point. Like you said, it would be a denial based on lack of verification.
Yes.
And that wasn't done, but I mean, that could have been what you actually submitted to the applicant.
Yes, but another way of putting that is that there is no evidence that she is eligible for Medicaid. And there's a separate rule of the administrative code, well, it's part of the same rule, just a different subsection, that directs the county shall approve an application for Medicaid if an applicant meets all conditions of eligibility and shall deny an application if someone does not meet all conditions of eligibility. And this also speaks to the second argument, the second assignment of error, which has to deal with prejudice. No prejudice can be found in this case because there is no evidence in the record that Ms. Johnson was eligible for Medicaid and that it would have made a difference. If her application had been, if the verifications had been sent while she was still alive, we don't know whether she would have been able to verify those transfers and that she would have actually been found eligible for Medicaid.
Now, you said you don't think there's anything in the record, or there may not be anything in the record about the November 16th payment from Medicaid. But was that discussed at all at the hearing? Do you remember that?
I was not at the hearing. I know the transcript is part of the record. I don't remember.
That's okay. I'm just wondering because when you said there's nothing, there's no evidence that she was eligible. Well, really, there would be evidence that she's eligible because they paid in November.
It was mentioned at the state hearing that she received and got coverage in advance for the month of November 2016. And then they were disputing she didn't receive coverage for August through October.
All right, thank you.
But I believe that I don't know why the county didn't try to rescind that payment. I don't think it should.
That's fine. I just was trying to figure it out.
But because there is no evidence in the record that Ms. Johnson was eligible for Medicaid, prejudice cannot be assumed. And regardless, again, until she is affirmatively found to be eligible for the benefits she's seeking, Ohio law prohibits the agency from approving her application. And the last thing I want to touch on is the due process argument from the state hearing. That argument essentially was that the state hearing didn't comply with due process because the specific caseworker wasn't at this hearing to provide testimony. The caseworker's testimony was not something that ODJFS was relying on for its part in the hearing. and a subpoena was never issued by Ms. Johnson's representatives for that witness to testify. So if they felt that her testimony was necessary, it was incumbent on them to issue a subpoena, request a subpoena for her presence. They weren't, the law does not entitle them to cross-examine a witness that ODJFS didn't present at the hearing and didn't rely on as part of their case. So there was no due process violation in the state hearing process. And the actual last thing I want to touch on is that as requested relief, Ms. Bachman said that they weren't necessarily asking for benefits to be approved, but they wanted the case reopened for consideration of the best evidence available, I believe is what she said. And I don't see how that would make a difference in the ultimate determination of the application, because they still have this outstanding list of transfers that the county felt needed additional information in order to verify and make sure we're not improper transfers. It doesn't sound as though Ms. Johnson's representatives are able to obtain any further information at this point. So I don't believe there would be any additional evidence for the county to consider. I think the application would still have to be denied for failure to verify resources or failure to meet the eligibility criteria.
What about their argument that if we were to uphold this decision and affirm what the trial court did, that the Ohio Department of Job and Family Services would have no incentive whatsoever to timely process an application, and could just sit on it, and then, years later, there would be no way to verify information, and everything would be denied then?
Well, there is a way to request a state hearing based on agency inaction. So if the agency is taking a long time to issue a decision on an application, I believe it's within 510135, which is the statute that authorizes state hearings, possibly in one of the associated rules. But a state hearing is permitted to be requested based upon agency action or inaction. So in that circumstance, someone should be able to request a state hearing to challenge the agency's inaction on their application as well.
Thank you.
If there are no further questions, we ask this court to affirm.
Thank you.
Thank you.
You do have 2 minutes and 17 seconds.
Thank you, and I just briefly want to touch upon a couple points. With respect to the payment of the November 2016 coverage, there was no notice that was ever issued rescinding that or denying it. I have been told by my client that they put in payment and the payment was processed. Now, I believe that to be true. I believe that that's been part of the record for some time, whether it be at the hearing at the lower court before the magistrate. I know that that section has been part of the briefing. I am not Amy Grover, just who did the initial state hearing, so I can't speak to what was said at the initial
Well,
state hearing.
we can only consider what's in the record.
Right,
anyway, as far as
right, but that's, the state hearing decision is part of it, and Amy Grover was at that hearing, but that wasn't me. So just to clarify, there was nothing written that ever rescinded that coverage, and I do know that Legacy Place billed for it. So that's the suggestion to me, that in the record it is indicative that she was eligible for some type of coverage, because they could have issued a notice and said, oops, by the way, this was wrong, you don't get any coverage, the coverage from November 1st to November 10th is, stopped, it's reversed, whatever. They could have issued a notice, they didn't. So with respect to the second point that I heard regarding the prejudice, so I just wanted to briefly address that. The prejudice here is the agency's delay. And then the harm that was caused by that is obviously the failure to be able to come up with these verifications or to complete something and make it available again after Ms. Johnson has died and her family has sort of dispersed and gone away from this. So the harm is actually the lack of payment that results from all of this unnecessary delay and the fact that this went on and on for all these months. Again, had everything been timely processed in the first place, even back, in October, November, even if it had been done in November, potentially, we don't know because the family wouldn't speak to us by July 2017, but potentially we could have verified some of those things. Now the results of those verifications are unavailable. We do know from COVID in particular that best evidence is something that the agency is able to take. And we know from the fact that the November 2016 coverage was never rescinded, that the agency is able to overlook things if they're not readily available. So,
Thank you, you're not.
okay, we're just asking that you reverse and send it back to the agency. Thank you.
Thank you. Thank you both for your presentations to the court today. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides as well as released electronically on the Ohio Supreme Court website. Thank you. Please stay warm out there.